Welcome to session 4 at the intersection of the legal definition of native title rights holders and the practice of authority to exercise rights. Today we have 3 co-presenters. Kevin Murphy, who's the manager of the Anthropology and Research Unit at Cape York Land Council, and he's been there for a year, and previously he worked as a consultant anthropologist for 20 years. And Louise Lopez is a staff anthropologist at the North Queensland Land Council for the past 5 years, and last year he participated in the CNTA writing placement, where he explored some of the issues to be discussed in the panel today. And Tony Redmond, who will hopefully be joining us a bit later, is a current adjunct senior research fellow at the Anthropology Department at UQ, and he has worked in the Kimberley, Cape York and South East Queensland, conducting research in native title and PBC development. So I'm going to read out a short introduction for the session. Native title holding group descriptions in the determination of the Federal Court are commonly defined by reference to a list of ancestor names. The composition of the list of ancestor names as a group description derives from the legal use of the anthropological input in the claims process. But in its final form in a determination, much of the complexity in the normative system around how rights and interests are distributed and who has authority to speak for and about country is elided. In this panel, they intend to explore what happens after a determination in the interaction between a list of ancestor names and the social processes involved in exercising authority to make decisions about land. So at the end, we'll have time for questions. So if you pop them into the QA chat, and Marie will pass them on to me, and I'll hand over to Kevin now.
The Mabo decision of the High Court determined that the Meriam people hold native title rights at Mer. Aside from recognising the individual plaintiffs in the case as Meriam people, it didn't attempt to define who the Meriam people are, although it's implicit that they understood them to be the descendants of the people who occupied the island at the time it was claimed by the British Crown in 1879. The legal process established by the Native Title Act requires that the question of who holds rights in any particular claim area must be set out in the determination. To quote, who the persons or each group of persons holding the common or group rights comprising the native title are, end quote. It seems to me that there are 3 main forms of grouping referred to and or created by native title claim group or native title holding group descriptions. Although there's some variations within each type. I'll call them the tribe, often but not always with a name derived from a language distinction, a local descent group, and the Western Desert Multiple Pathways group. I'm focused today on native title holding groups that refer to variants of the first 2 of these, but as a very brief aside on the issue as raised by John Morton in the last session, I don't see the Western Desert as providing a different type of system, but I'm concerned here with the representations of system as abstracted in native title holding group descriptions. In the early years of operation of the Native Title Act in Queensland, there were numerous claims that were determined by consent between the claimants and respondent parties, which described the native title holding group without reference to names of apical ancestors. On several islands in Torres Strait, the native title holding group was defined in the same manner as the Meriam judgment, using the name of the island and a suffix meaning people of. The Wik and Wik-Way determinations state that the native title held, and this is a quote from the determination, the native title is held by the Wik and Wik-Way peoples. And significantly, among the rights recognised by the court in that series of determinations are 1, to resolve disputes about who is or who is not a Wik person or a Wik-Way person, and 4, to resolve disputes between Aboriginal people concerning native title rights and interests in relation to the determination area, with the assistance of native title holders of adjoining areas where such assistance is necessary. So I consider these to be 2 variants of the language name tribe references. In the Hopevale determination, there are 13 clans named, but no ancestors are named in the group description. And in the Northern Territory, there are likewise numerous native title holding group descriptions in which clan estates are named, principles for affiliation cited, father, mother's father, mother's mother, but often without specified named apical ancestors. To return the focus to Queensland, since the time those determinations that I mentioned were made, claim group descriptions and the descriptions of native title holding groups contained in determinations are commonly now defined by reference to a list of apical ancestor names. Sometimes groups are defined merely as the descendants of the named ancestors. Sometimes it's explicitly stated that to include people adopted into the group. Some group descriptions involve qualifications on inclusion, such as that the group members must self-identify as and be accepted by the group at large as members, often with reference to a language, name, tribe identity. This common practice has evidently developed with endorsement of state respondent parties, as most of the determinations have been made by consent. And my understanding is that this on the part of the state is meant to be in the interests of certainty. The conventional process by which such lists have been compiled and found their way into claim and native title holding group descriptions involves the legal adaptation of an anthropologist report, whether this is in a consent determination or at trial. The anthropologist report gives an account of traditional laws and customs that describes what Sutton calls the classical situation, in which primary rights were acquired by serial patrifiliation, with secondary complementary rights in mother's country, and an account of adaptation by which cognatic descent has more or less become the norm, with the thread that links them and gets the state's agreement that the current system as described is traditional, being that both can be represented as based on the normative principle of descent. The reports generally also give opinions on who the native title rights holders are, with genealogies and family histories. Both of these abstractions are simplified to the point where, in my view, they don't accurately represent the reality of how rights in country were or are distributed between people, nor of how authority to make decisions in relation to country is structured. Pretty much all of the anthropologist reports on native title claims that I've read provide substantial detail on such matters, including on the manner and circumstances in which people acquire and transmit rights in country through mechanisms other than descent. But in the reduction to formulaic ancestor lists, the complexity is elided. Similarly, absent is any accommodation of the relationship between underlying and approximate title, as raised by John Morton in the last paper, and the significant fact that the relevant scale of group involved in making decisions about land varies according to context. There is, of course, a fundamental difference between these abstractions in as much as a unilineal system is intrinsically exclusive, whereas a cognatic system is exponentially inclusive. For a unilineal system, for the acquisition of primary rights to remain functional over time, there must be a mechanism for succession to vacant estates, which we've heard quite a lot about in the previous session before lunch. And for a cognatic system to be functional over the long term, there must be mechanisms for preferencing and exclusion. As I've intimated, there's a lot more going on than the abstraction contained in the list of apical ancestor names suggests. And in a moment, Lewis is going to discuss the social dynamics involved in the inclusion or otherwise of people who are discovering their ancestral connections to country after several generations of removal. And Tony, if he manages to join us, will talk about some of the filtering factors that are involved in the exercise of rights and their recognition as legitimate in terms of law and custom. But before I hand over to them, I want to just add some further context to the way in which I see the issues likely to arise as lists of apical ancestors come to be implicated in the politics of inclusion and exclusion in the future. The anthropological evidence in the Torres Strait Sea claim, Jeremy Beckett, Colin Scott and I were called as witnesses by the claimants in that claim. That evidence described the normative system involving, in Colin Scott's terminology, primary, secondary and tertiary rights, with primary rights usually acquired by patrifiliation, although since colonisation numerous people have acquired such rights through matrifiliation, and the capacity in the system for secondary and tertiary rights to be converted into primary rights in certain circumstances. The judge ultimately decided that it is only primary rights that are recognised as native title rights, these being rights in rem, whereas he regarded secondary and tertiary rights as rights in personam, and he found that those rights are not recognisable as native title rights. Now, this aspect of the decision was appealed as far as the High Court, where it was actually upheld. So in Finn's finding, Justice Finn in the primary trial, in Torres Strait, primary rights are now acquired by cognatic descent, and he lists the claimant's ancestors' names in the native title holding group description in the determination. Now, with the recent amendments to the Native Title Act that require a PBC to accept membership applications of anybody who is a common law native title holder, Two consequences in particular seem likely. First, where there's a list of ancestor names defining the rights holding group, this is prone to be deployed in competitive politics within PVCs. And second, where there is no such list, there is a strong possibility of extensive future litigation over whether people who have been refused membership of a PVC are in fact entitled to membership as common law native title holders. So that's my introduction of the topic, and I'll hand over to Lewis.
Thanks, Kevin. Well, hello, everybody. I'm Luis. I work with the North Queensland Land Council. What I would like to talk about in this panel is the relationship between authority, claim group membership, and what I term returnees. Now, these matters are explored in the context of Queensland, but it is likely that they apply to other parts of Australia. I use the term returnees to refer to those Aboriginal people whose ancestors' connection to country and landholding groups was disrupted by the colonial regime, either through forced removals from their traditional lands or fear of identification as an Aboriginal person. Due to this disruption, their descendants have not been able or were not able until recently to return to their antecedents' country and have not been active in the social fabric of their antecedent society. In light of documental or ethnohistorical evidence establishing an association to a name, landed group, or location or country, such as Tyndall's genealogies, these descendants have sought to take an active role in land claims and land management matters. Another common term used to describe the situation is people coming out of the woodwork. The identification of returnees in landed groups has in fact been greatly facilitated by native title research, particularly through the emphasis of identifying descent groups based on named Aboriginal people associated with a claim area or named landed group at the time of British settlement. It has been further exacerbated by the increasing requirement from respondent parties, such as the state, to rely on archival sources necessary to prove an ancestor's early association to an area and continuous connection by their descendants. Consequently, a number of Aboriginal people previously socially and politically inactive in landed groups have returned and pursued an active role in land claims. In many cases, returnees' involvement in land matters is cemented and reproduced during communities and authorization meetings, usually called and organized by NTRBs. Now, the membership status of returnees raises important legal and anthropological questions about the composition of landholding groups and governance of country. Some questions, for example, is, can returnees be considered part of a society when they have not been active in it? What's the role of the community in recognizing the rights to country of returnees? And what will returnees' role be in decision-making about land? These questions become very relevant when looking at how landed groups deal with the membership status of returnees. So while working in rep bodies, I often encounter this scenario. An ancestor is identified as likely having connections to a landed group. Usually in these cases, the archival material is consistent with such a conclusion, and the recommendation put to the group is that the descendants of these ancestors likely hold native title rights and interest in a claim area. The question for the group and for the rep body then is, are these people part of the landed group or not? There are usually mixed responses to these situations. It has been my experience that the community acceptance of returnees as members of landholding groups usually requires prior involvement in the social fabric of the group and the activation of the landed identity. The respectful reintroduction into the group is a key aspect of this. The expected protocol is usually for returnees to come back to learn about country by asking the appropriate elders and visit country. They have to reconnect with lost kin and participate in social activities such as funerals and claims meetings. Significantly, returnees are expected not to take an active or performative role in decision-making about country until they are seen as having been fully integrated into the community and learned about law and custom. And even then, their involvement in decision-making can be a bit contentious. Usually following this process, returnees become fully accepted as part of landed groups. On the other hand, I have often also encountered situations where there is continuous conflict about group membership involving returnees. This conflict can involve the rejection of the families of returnees on the basis that they are not from here or that they are not bloodline. and returnees rejecting other families on the basis that they do not have the necessary archival evidence to support their connections. Conflict about the composition of a claim group can escalate and has the potential of becoming crippling to the progression of native title claims. In those cases, rep bodies or the court usually end up mediating this conflict and tend to support the inclusion of those with reasonable anthropological evidence, which usually includes returnees. However, the outcomes of these decisions are typically short-lived, and membership disputes can lead to very dysfunctional PBCs that continue to struggle with the same issues. After determination, there are further complexities that arise. The most evident one is that PBCs have not clear mechanisms to deal with people coming out of the woodwork. This includes those whose ancestors were not identified in the original claim process, and also those native title holder families who simply have not been active in the landed group for generations. Another evident problem is that poorly structured PBCs tend to be dominated by some family groups, usually the ones with most members. In some cases, returnees families end up running PBCs, which can create tensions within the landholding group about benefit distribution, protection of significant places, and authority more generally. On the other hand, it can also be the case that returnees families are completely excluded of any type of participation in PBC matters by other families. Now, there's really no easy answer to this matter, and it is further complicated by internal politics, procedural fairness, social justice, the requirements of the Native Title Act, and PBC rulebooks that in most cases do not consider the complexities of the social dynamics in decision-making in Aboriginal society. Too often, disputes about membership in Native Title have been restricted to legal and anthropological assessment, which have created great tensions between landed groups and native title practitioners. I think that key to this matter is the authority of the Aboriginal general public in making this type of decisions, and that anthropologists have a role to play in exploring in more details how rights to country worked amongst landed groups to inform this type of decisions. This is not a simple task, as in most cases, there is no framework to define the authority of the general public, as it usually gets lost in generic legal definitions of who are the people that can exercise rights to land in native title claims. So that's all from me for now. Has Tony joined us? I'll just hand over to him, and he will explore more the role of the general public. Thank you.
So in my view, anthropological models which focus their attention exclusively upon descent-based corporate group membership without paying adequate attention to the wider interpersonal world of lateral performative kinship cannot adequately account for the principles which enable a person to negotiate their involvement in group decision-making processes. The more structural models focusing upon the dual status of descent groups in isolation from other factors tend to leave unexplained the deeply rooted negotiability, indeterminacy, and agency, even in so-called tradition-orientated Aboriginal social worlds. Sutton noted some 20 years ago that people with descent links to a country but little or no history of a social relationship with those who live on or near it may find it difficult to put into action the rights they hold in principle, especially where their descent link is rather oblique. And this is the case with one of the instances I'm going to be discussing today. So members of a potential claim group are able to appeal to traditional precedents when they are circumscribing the membership of the group in relation to other persons whose right to be heard, but not necessarily automatically accepted on these matters, are established through their genealogical, or as people say today, their blood tie to one of the recognised apical ancestors defining a group. In my experience, genealogical connection to apical ancestors establishes rights and interests in potentia, which requires substantiation into actual rights and interests through a wider dual public recognition. Sutton described some situations in which people associated and unambiguously with a particular area will seek to limit the dimensions of the claimant or beneficiary group to those with activated rights. This biographical aspect to narratives of landed connection is often employed in an agonistic fashion to compare one family's strength of association against another's. Alongside that distribution of traditional rights, according to principles of maybe language identity, of country and or descent group membership, the contemporary facts of personal characteristics, life history and practical experience may also be called on by competing sets of claimants to validate claims of ownership. Competing claim groups may cite their own record of having walked around in the claim area, having camped and or worked there, knowing the important places, having relatives buried there, etc. They may in turn deny ever having seen their opponents in the area during those periods, question their opponent's knowledge and their ability to tell stories or sing songs for that country, and may sometimes cast aspersions upon their opponent's statements about their forms of connection. Similarly, each group may in turn cite comments from senior people belonging to the opposing group with whom they have working relationships and whom they consider to be genuinely knowledgeable to undermine their opponent's claims. The important point here is that wider group recognition is the sine qua non of being able to realise inchoate rights and interests. In my experience, this kind of group recognition relies heavily upon senior core group members' recognition of a particular person's claims of connection to country and or to a particular apical ancestor. As far back as 1980, Palmer and Kingsley Palmer and Nancy Williams differentiated between actual, potential and inchoate rights and interests in terms of what they called the specific conditions which must prevail in order for inchoate rights to become realised on the ground. So they say Aboriginal systems of land tenure, there are rights which are realised, which are inchoate. They are not simply potential, but they actually exist, requiring specific conditions and acts in order to be activated and realised. So, you know, all of us who've worked in native title have been, you know, taken on board seriously Sutton's caution against asserting a context-free or automatic hierarchy of rights and interests in the native title context. He suggested the better approach is to, as he says, present as clear an account as possible as to who hold what kinds of rights and in the eyes of whom. This in the eyes of whom is the crux of the group recognition process, in which considerable weight is placed upon the assent or disagreement of senior core recognised estate members. In my experience, merely being a member of a cognatic set of descendants doesn't automatically entail recognition that all the people in that cognatic group are automatically considered to be part of a particular landholding entity. What we are dealing with here is often a fundamental mismatch between legal and anthropological notions of the source of rights and interests in land. People will recall that Finn had found what he called status-based relationships involving even compulsory reciprocity or respect did not, in his view, under Torres Strait customary law, give rise to rights in relation to land and waters. But while Finn gave the opinion that these reciprocity-based rights and interests are not in relation to land or waters, for most anthropologists, rights and interests are always constituted in relation to other persons. Ownership of property in any land tenure system can only be recognised and sustained by defining the nature of the social relationship between people who are purported to be possessors of rights in a property and those who acknowledge the possessor's right to hold and exercise those rights and interests. A couple of ethno-legal scholars, von Bender, Breckman and Weiber, for example, have pointed out that unencumbered ownership of land is extremely rare globally. It may not be sufficiently recognised, they say, that human beings do not own land. What they own is rights to land, that is rights vis-a-vis other human beings. and different people may hold overlapping rights over the same land. So the question of recognition by the general public became a central issue in a recent case in which I gave evidence. The Indigenous Respondent Party had what Sutton called a somewhat oblique kinship relationship to people more broadly recognised as having an ancestral connection to the particular claim area. However, a long-running dispute had led to the respondents' broader family group claiming that the entire claim group belonged exclusively to members of a sub-branch of their own language group, and that no others could possibly hold rights and interests there. My argument was that while the kin relationship was oblique, it did provide a potential pathway for the respondent to be accepted as a member of a properly constituted claimant group for that area. There was evidence supporting the respondent's assertions of this connection to the claim area, but the respondent's claim to exclusivity had somehow quite visibly short-circuited the ongoing process of recognition via that oblique relationship. This then led to an argument about whose recognition was required to become a member of the landholding group, which over 20 odd years had split into two competing factions, aligned and identified on language group grounds. In her decisions on this case, Justice Mortimer cited from Dempsey, namely that recognition by other members of the claim group was not pleaded to be a requirement under traditional law and custom. The consequence is the state submitted that the court's finding and decision about whether the person known as Bunny was a person who traditionally held rights and interests in the claim area will be the operative decision, contrasting this to the situation in Applin on behalf of the Wanyuu people, where recognition and acceptance by the broader group was said to be an essential element of possession of rights and interests under traditional law and custom. Mortimer found in this most recent case that it was not in what she called the gift of what is in substance and opposing a rival group to demand that their contemporary agreement and recognition be secured. And even though the applicants had drawn a distinction between inchoate rights and potential rights, which it contends apply to a person who is possibly connected to an applicable ancestor, but requires public recognition of that filial connection before their rights can be said to exist. She said recognition in that instance is simply of the fact of descent, recognition that that person was descended from the applicable and does not require group acceptance of that person. So in summary, in my experience, descent of serial filiation provides only the prima facie basis for potential inclusion in a landholding group, because a range of what Sutton and Peterson have called filtering factors are also employed to consolidate and circumscribe the connections potentially established by descent. In effect, descent provides a legitimate basis through which a person is able to publicly assert their relationship to another member of the claim group and or an ancestor, but the principles for membership of the landed group are ultimately consolidated through social recognition afforded by other members of the group. Here, the performative aspects of kinship play a critical role in obtaining this kind of wider dual recognition of one's social and thus landed status.